Oh, yeah.
Judge, thank you, and good morning. Good morning to everybody in the courtroom. Judge's defense's motion to dismiss the indictment. We submitted briefs on it, Judge. I'll frame the argument, frame what the issue is here, and that is the state presented to the grand jury on December 11th, 2024, the charges in this case. And the original charges were of importance were the leaving the scene, but more importantly, the second degree vehicular homicide, death by auto, or reckless vehicular homicide. After the presentation, Judge, the grand jury returned a true bill for 6 counts, 2 for first degree aggravated manslaughter, 2 for second degree reckless vehicular homicide, 1 count of fourth degree tampering with physical evidence, and 1 count of second degree leaving the scene of a fatal accident. Judge, the first focus to frame this is on the presentation, the dismissal of the 2 charges or 2 counts of first degree aggravated manslaughter and the 6th count for leaving the scene of a fatal accident, Judge. The reason for that is under State versus Hogan, there's an argument to be made that the state failed to present a prima facie case of each element of aggravated manslaughter, that the state failed to present a prima facie case for leaving the scene of a fatal accident, and that the state presented what's the court in State versus Curtis said, a distorted version of the facts by presenting only half-truths to the grand jury. And the grand jury, Judge, in the scheme of the criminal justice system, is the first step after charges for the state to move the case forward along. And it's an important function. It's one that's guaranteed by the Constitution to all defendants. They all have a right to have the case heard by a grand jury. And what is the grand jury's role, or what is the state's role, Judge? And that is, in seeking an indictment, the prosecutor's evidential obligation is to present the prima facie case that the accused has committed a crime. And nevertheless, in establishing a prima facie case against the accused, the state may not deceive the grand jury or present evidence in a way that is tantamount to telling the jury or the grand jury a half-truth. And I'm going to quote this, Judge, from State versus Hogan at page 229, and that is, the grand jury cannot be denied access to evidence that is credible, material, and so clearly exculpatory as to induce a rational grand juror to conclude that the state has not made out a prima facie case against the accused. If evidence of that character is withheld from the grand jury, the prosecutor, in essence, presents a distorted version of the facts and interferes with the grand jury's decision-making function. Judge, there's case law out there. There's an analogy that the grand jury is not only a sword for the prosecutor to move a case along, but it's also a shield to protect the defendants and the accused from overzealous prosecution or overreaching by the prosecution. So, Judge, let's start with the aggravated manslaughter counts, which are counts 3 and 4 of the indictment. The elements that the state needed to prove or present, not prove, Judge, but present to the grand jury of aggravated manslaughter is that the 1, defendant caused the victim's deaths, that 2, the defendant so recklessly did so, and 3, the defendant did so under circumstances manifesting extreme indifference to the human life. And those are 3 elements, Judge. We concede the first one, that the defendant caused the victim's death, and that's based upon the autopsy reports. That the defendant did so recklessly, and Judge, I'm going to concede that just for this motion. The reason for that is under the reckless vehicular homicide counts in 1 and 2, the recklessness element was that Mr. Higgins had driven under the influence, because there's that certain section in that statute that when somebody is driving in violation of that statute, 39:4-50, that rises to the level of recklessness, where a state could then prove a case for the second degree charge of reckless vehicular homicide. But the third issue here, Judge, or the third element, is that the defendant did so under circumstances which demonstrate that the defendant's conduct was done so under circumstances manifesting extreme indifference to human life. And that's where we go the difference between a second degree death by auto, where there's just recklessness or drunk driving, to a higher element or a higher crime or a more severe crime of aggravated manslaughter, which needs to take into account, Judge, the drunk driving or recklessness, and then recklessness that is so high that the defendant's conduct would probably have caused the death of another person. Not mere possibility. It rises up to the probability, Judge. And that's in State versus Curtis in the appellate division, Judge, from 1984. It's the risk that the defendant caused by his conduct, which is the factor. It's not what's in his mind. It's not his intent. It's not his intent to pass somebody. It's the conduct. When you look at it objectively and rationally, did the conduct rise to the level of extreme indifference to the value of human life? Here, the facts of the case, which have been brought out in court through motions, has been put out all over the globe in social media and also through the press, Judge. The facts are that Mr. Higgins was driving home from Taco Bell around 8:30 at night. It was dark. Judge, the evidence that we have so far in discovery shows that the two bicyclists were on the right side of the road riding their bikes on the shoulder. And the shoulder, Judge, is less than a foot wide. So it's not even really a shoulder. It's just the side of the road. As Mr. Higgins was driving, the speed limit was 50 miles an hour. There were two cars ahead of him, a Ford Focus and then a Ford Bronco. Mr. Higgins, as the grand jury heard, said that he was traveling about 30 or 40 miles an hour, or maybe 30 or 20 miles an hour, coming up because he thought the other cars were going slowly. And he sped up, as you see people often do to signal to the other people, you got a car coming up, you're not going the speed limit. He goes to pass the Ford Focus on the left lane, which was allowed. It was Trooper Pope, the grand jury, the presentation said it was a dashed yellow line. So there's no extreme recklessness or any recklessness in passing that car, Judge, although witnesses said that it came up at a high rate of speed, but we don't know what the speed limit is. We know that the one car, the Ford Focus, was driving at around 50 miles an hour. Mr. Higgins passes on the left and he tells the police, but it's not presented to the grand jury, that he went back to the right because the Bronco, the second car, had moved over into the left as Mr. Higgins was passing the Ford. So what he did was, not knowing what that Bronco was doing, he went back into the lane. The state presents this as he was trying to pass the Bronco on the right. However, what Mr. Higgins explained to the troopers was, that Bronco went left. I don't know if he was trying to stop me, not sure what he did. So I went back into the lane. And unfortunately, when he went back into the right-hand lane, Judge, that's where the two bicyclists were. And it was an immediate impact. Mr. Higgins did not see the bicyclists because he was passing the one car. And the state had pointed out that there is a statute under Title 39, and I think it's 39:4-10. In that realm, Judge, that bicyclists are supposed to have reflective gear on, and that's statutory, and not reflective gear, Judge, lights in the front, lights on the back, but then there's also added protections. And for the record, before I go any further, and this can just address concerns of the state and the public, Mr. Kleinberger and I are not blaming the two bicyclists for the incident. That would be ridiculous. That would be wrong. However, as Mr. Mestern said, defense attorneys are doing their due diligence. We're required to do this, sometimes this fishing expedition, as we call it in the law. We are required under the Sixth Amendment to investigate cases. We are required under the Sixth Amendment to provide effective assistance to our clients, to those who are charged with crimes. That's what we are doing. We are going through the motion practice solely and primarily to make sure that we do our jobs as defense attorneys to uphold the Constitution. Not to fight about blame right now at this part of guilt or innocence, Judge, but it is to protect Mr. Higgins under the Constitution to make sure that he gets a fair trial or he gets a fair shake at the defense. So that's what we're doing here, Judge. So as he pulls back over, the two bicyclists are hit. Unfortunately, they pass. The car that he's driving, his Jeep, is then disabled because a wire from one of the headlights had popped off. It caused the car to stall. We know that because Trooper Pope, on behalf of the state, did an accident reconstruction and said that the Jeep would stall out if all the wires were connected. Indeed, that's what happened here. The incident caused the Jeep to stall. And then it traveled, as the state continues to point out in its brief, 0.2 miles or 1,500 feet. And then the state alleges that the defendant did that to leave the scene of the accident. If we go back a step, Judge, there was evidence that was presented to the grand jury in Trooper Pope's report that they reconstructed or tried to imitate what happened that with the 1,500 feet. Trooper Pope took an older troop car, went out onto the road in the area and drove it to 50 miles an hour, and then put it in neutral or took his foot off the gas and let the car coast. That car went 4,500 feet, just going and going and going. And what Mr. Higgins traveled was 1,500 feet. The state was harping on that, and I'm going to get into this later, Judge, when I talk about the dismissal for that aspect of it, Judge, that was evidence that he was leaving the scene of the accident. The state then cites cases that say, and I believe one is, I'll say the name and I'll say it wrong, Radziwill. And in Radziwill, they say that a jury may infer that an individual who drives while intoxicated, and this is getting back, Judge, to the aggravated manslaughter. The jury may infer that an individual who drives while intoxicated is consciously disregarding the risk of an accident and acting with extreme indifference to human life. The state would then proffer, Judge, that this is what Mr. Higgins did. However, Judge, when you look into the cases of Radziwill and some of the other cases, the intoxication level of the defendants was so high. And these are in the cases of State versus Johnson, which the prosecutor cites, as well as one other case, Judge, where, and I'll say that on the record, is State versus Machuzak, Machuzak, where they're saying that the intoxication in and of itself could be the extreme indifference to the value of human life. The problem, though, Judge, with those two cases are incredibly distinguishable from the fact here, where the court was pointing out at great lengths the fact that the defendant in both of those cases was severely intoxicated. There was evidence that he was acting belligerently, that he was being loud, he was obnoxious. In the one case of there was a defendant in a bar, and they developed a record that he had a habit of going to the bar almost every night and getting hammered, for lack of a better expression, to the point where both of the defendants were so severely intoxicated that the court found that could be an extreme indifference to the value of human life, where in this case, as we all know, Mr. Higgins' blood alcohol concentration was a 0.087. He went 0.007 over the legal limit. There is testimony from Trooper Pope that said that he spoke to Mr. Higgins' wife after the incident. She said that she had spoken to Mr. Higgins on the phone, and he did not seem drunk at all. She attributed things in the case to potential impatience. So we've got now passing on the left of the first car, which is proper. We've got drunk driving alleged, but it's a .087, which is a lower level. We've got a dark road. We've got bicyclists on a very small side of where they are allowed to travel, which they should only do during the daytime, Judge, and I'll get into that. We don't know the actual speed of the vehicles. We do know that Mr. Higgins just coasted afterwards and then stopped, and we'll get into the fact, Judge, that he actually stayed at the scene and did the field sobriety tests. And at that point, Judge, all we have is the vehicle coming up at a high rate of speed and then passing properly. The state states and presents in the grand jury transcript another aspect to bring the case to the extreme indifference to the value of human life is that Mr. Higgins's car went halfway onto the grass off the road. And three of the witnesses testified to that at the grand jury. But that's not what happened because we have Trooper Pope's diagrams, which I attached, Judge. I think that's Exhibit C on my brief. And also in the grand jury exhibits, we see Mr. Higgins's Jeep afterwards at its resting point. We could see the 360 degrees from all the different pictures, Judge. There's no mud, and it rained later that day, but at the time of that night, but at the time of the accident, it was drizzling, and the ground was wet. There's no mud on the car or splatter from the mud, showing that if he was driving at such a high rate of speed, it didn't kick up any of the grass. It didn't kick up any of the dirt on the side of the road where the witnesses said he drove. And of particular importance there's photographs that don't show any tire marks whatsoever. In fact, Judge, there's an issue here about where the actual point of impact was. On the road, out of this small shoulder, off of the shoulder. We don't know, Judge, because Trooper Pope didn't have the empirical data that he saw at the scene to find that and to give a conclusion on that. Okay, Judge. So that's what's presented. Furthermore, it's presented about the fact that he was intoxicated, but I dealt with that, Judge, under Radziwill. Judge, another factor that a court considers, and this is where I'm looking now, Judge, at State versus Radziwill at page 863, is that it talks about relevant circumstances being objective and not dependent on an actor's state of mind. Radziwill then quotes the bogus matter, State versus bogus. They upheld a conviction for aggravated manslaughter based upon evidence that the defendant drank, and I'm going to quote, to the point of being severely intoxicated, and then drove his truck on a main thoroughfare at an excessive rate of speed, proceeded into the intersection in the face of a red light. The court stated that the jury could conclude that the decision to drive and the manner in which the defendant operated his motor vehicle indicated a complete disregard for the lives of others. You get back to Radziwill, the court says similarly, the evidence in this case provided sufficient support for a conviction of aggravated manslaughter, that the jury could have inferred from witnesses' testimony concerning the defendant's habit of becoming intoxicated at a particular bar on the weekends, that he was highly intoxicated at the time of the accident. The jury could have concluded that one of the witnesses' testimonies was that the vehicle was struck from behind by the defendant's vehicle, traveling at a high rate of speed, and that the defendant did not have control over his vehicle. These are the parameters, Judge, that courts have set out under particular sets of facts that would justify aggravated manslaughter, which are lacking in this case, Judge. There's no evidence in this case whatsoever that Mr. Higgins did not have control over his vehicle. In fact, he had such control over the vehicle, Judge, that he went to move away from the Bronco because he didn't know what the Bronco was doing and properly pulled into that right-hand lane. The next question becomes, well, how fast was he actually going? Well, if he was going 50 miles an hour, which is the posted speed limit, then his Jeep, similar to Trooper Pope's car, would have traveled 4,500 feet. Didn't. Traveled about a third of that. It's 1,500 feet. The state presented evidence that Mr. Higgins, based on his statement that he gave to the police, was that he kept pumping the gas pedal, the accelerator, obviously trying to flee the scene. The car had already stalled. We don't know what that was. That's not a proper or a proper truth to put to the grand jury, because the grand jury didn't hear it. There's other explanations which were not asked of the trooper, like, well, if you're 1,500 feet away or 1,000 feet away and you're pumping the accelerator because the car's not operating, it could very well be that you're pumping the accelerator to get the car to start, to turn around, and to go back. If he was going to leave, he would have left. He had many opportunities to do so, and he didn't, Judge. Judge, one of the things that we've brought up under the case of State versus Tejan is the Tejan. We're talking now about the bicyclist blood alcohol concentration and the fact that they obviously were intoxicated. So one of the bicyclists' blood alcohol concentration was a 0.129. Other bicyclists' blood alcohol concentration was a 0.134. We know that the drunk driving statute doesn't apply to bicycles because bicycles are powered by human power as opposed to combustion engines or electricity. The judge in State versus Radziwill said bicyclists are not subject to, or State versus Tejan, I apologize, Judge. The bicyclists are subject to the same rules and regulations that cars are. However, Judge, we know that that's not true because the definition of a bicycle is not the same as the definition of a motor vehicle. Judge said, though, and this, go back to the days of law school, hardly use this word anymore, not the holding judge, it's dicta. Now, it's from a law division. I'm well aware, Judge, that that law division case is not binding here, but we have a split decision. The judge in Tejan said that although, or the duty imposed by the drunk driving statute is to refrain from operating a motor vehicle when intoxicated. However, the drunken operator of a bicycle may create situations endangering both himself and others on the road. He might, for example, swerve into traffic, cross the line into oncoming traffic, or fall into the path of traffic. Therefore, the operator of a bicycle is under an obligation to stay off the roads when intoxicated. We've got another case that came out, Judge, that holds the opposite, that you can't convict somebody under the drunken driving statute for riding a bicycle. And then there's a third case that comes out that sides with the second case I cited.